new memorandum has gone out from Cersei Owen, the acting director of EOIR, the company over all the immigration courts and judges, saying that they're encouraging judges to deny immigration asylum cases as early as possible if they have legal insufficiencies. And the legal insufficiencies are things like the asylum was filed more than 1 year from when the person had entered the country. Another legal insufficiency could be that they couldn't prove connection between the protected ground, religion, political opinion, social group, nationality, or race, and the persecution. In other words, they couldn't prove that they were being abused directly because of their protected group that they're in. And finally, statutory bars. For example, the person had serious criminal convictions, so they're not eligible for asylum. What does that mean? That means when you file a case with the court, you come to the hearing, the judge looks at it and the judge says, hey, I don't think legally you have a winning case. They can deny you right at that first informal master calendar hearing. They're not even going to wait in many cases for the big individual hearing. They're now going to be denying you right at that first preliminary hearing. So this means now more than ever, you need to get a lawyer. And from the very beginning, when you're filing your case with the court, your lawyer should put in a brief describing your whole story. So that means you have to write the whole case from the beginning. You're writing your whole big story in court for what's getting submitted to court. Your attorney is going to include a brief explaining how your case legally complies with asylum law requirements, and that you have like a more or less winning case. Otherwise, the judge can even skip your individual hearing and just start denying left and right at the master calendar hearing without making you go through the entire hearing, giving many judges who are not very immigrant friendly, it's like untying their hands to clean up their calendar. This memo is meant to help judges clean up their calendars and make space on them and expedite. So they're saying that pre-termission or rejecting cases as early as possible, it's not mandated, like they don't force the judges to do this, but it is permitted. It's allowed if the judge wants to do this. So this means your lawyer should prepare a strong legal argument, a full, strong story right from the start. You can't rely on having that individual hearing to flush out your case. You have to anticipate and argue disputed facts right from the beginning. So if you want a hearing, you got to show that there's something to prove at the hearing, and you have to file legal briefs, cases, precedents, your legal arguments right from the very beginning, making it more than ever a mandatory thing for you to have a really good immigration lawyer. We are here to help. For any asylum cases in any of the 50 states, give us a call today.